I was involved in a multi-car accident and received a letter about a global settlement conference. What is that, and what does that mean for my claim?
So, global settlement conference is something that you might see when you're dealing with an insurance company that has a limited policy and multiple people making a claim on that policy. For example, if there were three cars in an accident and each car had several people, let's say there's like five people, we can make up any number, but anything above two people, at least
Hmm.
three people making a claim on this particular at fault person's policy or this particular policy that's available to multiple people,
Hmm.
then that insurance company can conduct something called a global settlement conference. The way it's conducted is just like a mediation. So a mediator is hired to conduct this conference, and then all of the parties get together. Nowadays, since COVID, we've been able to do this via Zoom, so we can do it from the comfort of our office, or if our clients are there, from the comfort of their home. You don't have to physically get together. Sometimes you can, and sometimes that's beneficial too. But we do this global settlement conference where we all get together with all of the attorneys involved, all of the injured parties making a claim, and then we try to come to some agreement about divvying up this money. Usually, what it is, it's basically the best or the fairest solution in an unfair situation. Because remember, you're dealing with a pool of money that's probably not enough money to compensate everybody that's injured. We recently had a closing today in our office for a global settlement conference case where my client took all of my advice. She listened to me beautifully, and she really followed the doctor's instructions. She had her MRIs when she was supposed to have her MRIs. She went to a specialist to get a consultation regarding the findings in her MRI, and she really followed my instructions. Other folks didn't really do much. They might have went to chiropractic treatment a couple of times, didn't follow the doctor's instructions, didn't really follow through with treatment, and had a couple of visits here and there. And my client walked away with significantly more than the other folks. So when you have a global settlement conference, the most important thing to do is to come up with a tailored plan with your attorney, because every case is different, and sometimes you're trying to figure out what pool of money am I dealing with, what are the circumstances in my case. If you're dealing with a really, really small pool of money and that's absolutely all that's available, you may not want to really go all out there and just rack up high medical expenses if you don't have to.
Hmm.
Obviously, if you have to, then you have to do what you have to do. So you want to take all of that into consideration. I had another global settlement type of case where my client had to have surgery, an emergency surgery for a spleen rupture, and the other folks, they had bad injuries too, but they weren't as bad as his. And then he walked away with the full policy limit that was available for any one person, and then the rest of it had to be divvied up and split between the other folks that were injured. So it's really important that your attorney understand your injuries, understand your case, so when they go into this conference, they can present it. Sometimes the attorneys can even gather information from other attorneys or from the insurance adjuster regarding the other folks. What are their injuries? What do we know about what they're experiencing? And how does it compare to what you're going through? The most important thing is for your attorney to be able to present your case so that we can maximize your recovery in what very well may be an unfair situation.
Amazing. I was a passenger in a multi-car accident and suffered from some bad injuries. How do I know what insurance I can go after, and can I only go after the person who caused the accident?
So as a passenger, of all of the categories of people that you can be involved in an accident, you have the most, or the possibility of having the most insurances available to you. The first thing we do as personal injury attorneys, the first thing I do here is I look for all of the insurance policies that are available to you. And the first one that I would start with is the person that caused the accident. I look for the owner of that vehicle, their insurance, and then I look for the driver of that vehicle, their insurance. And if there are multiple people that caused that accident, then you can go after every single owner and every single driver. So there's a multitude of insurance policies that could possibly be available to you, because each person would be responsible for whatever percent of the accident they caused, or whatever we determine that to be. They would be
Hmm.
responsible for that percent of your recovery or your overall injuries. On top of that, we can look for the vehicle that you were in. We can look for the underinsured or uninsured motorist policy there, and you can make a claim there. And even more beautiful than that, if all of that money is still not enough, including the uninsured motorist policy for the vehicle that you were in, you can make a claim if you do have underinsured motorists on your own auto insurance policy. That's the last policy that you can make a claim on too. So you have a multitude of insurance policies that you can make a claim on as a passenger in a car accident claim.
That's good to know. I feel like I need help with my claim, but I don't want to sue the person who hit me because they are a close friend. What should I do?
So interestingly enough, I have heard that case, that kind of circumstance play out several times. Usually the fact pattern is that you're driving in your neighborhood and your neighbor hits you, maybe at a stop sign, maybe a rear end, or whatever happens there. Maybe they're pulling out of their driveway, but it's usually a neighbor thing, or sometimes you're following a friend and a car accident ensues like after that. And people don't want to go after their friends, but what you should keep in mind is that sometimes it's not personal, it's insurance companies that you're making a claim with, and that's why we all have insurance, to protect us in circumstances like that. So if you're the person that's injured in the accident, then you don't want to be at a disadvantage when somebody has like insurance. I think the most important thing to understand is that you're not making a claim against that person personally. I even had a claim where I represented a wife that was a passenger of the car, and we ended up finding out that her husband, who was a driver, was at fault for the accident. And the husband said to me, "Can't you sue me?" Well, technically you can't in Florida for other reasons beyond the scope of this podcast, but they weren't legally married. So we ended up making a claim under his permission and his guidance with his insurance. And it happened to be her insurance too, because they were living together and they just weren't legally married, and she made a claim under his insurance and they still remained happily together, but he did end up being deemed at fault for the accident. So it's possible, and it's not personal. It's really just a claim against insurance, and you're dealing with these bad circumstances in the best way.
You're just trying to protect yourself.
Exactly, you're dealing with the bad circumstances in the best way possible.
Amazing. What are the most important steps I should take after being involved in an accident to protect my case?
After an accident, the most important thing that you can do is take care of your health. If you think you have an emergency health situation going on, maybe internal bleeding, you hit your head, really bad headaches, if you think you have broken bones, you're going to want to go to the emergency room to make sure that you're okay. You can use the ambulance for treatment like that. If you don't think you have that type of emergency treatment, you're going to want to contact a skilled attorney. And then there are a couple of things you can do to protect your claim before you contact that attorney and even after. The first thing that I always say is don't talk to any of the insurance companies. You may get calls asking for interviews. You may get calls asking for recorded statements. Do not give any of those statements until you speak to your attorney, and your attorney can give you guidance on the parameters of that. Most of those communications will go through your attorney's office. Okay? You are going to want to not post anything on social media about the accident or anything at all. Don't even post, "Here's a picture of me at a restaurant," because if somebody sees that, the argument is going to be, if you were so injured in the accident, how did you go to a restaurant the next day? And that's just one example. There are 10 million versions of that. And then when you do get to your doctor, whether it's in the emergency room, whether it's in an urgent care, whether it's in a chiropractor's office or wherever, you're going to want to make sure the doctor knows everything that's wrong. So I'm going to give you a hypothetical situation. If you were involved in a car accident and you hit your head on the windshield, for example, and let's say you also hit your you also hit your knee on the dashboard. When you go to the emergency room, you might primarily be concerned with your head, because obviously that's worse of an injury of the two injuries, because you can die from that. Most likely you're not dying from a knee injury. So let's say you go to the emergency room and you just report that you hit your head. And then the doctors clear you, you're fine, you get worked up, and then a week later you go to an orthopedic about the knee pain that you're having, and now you report the knee pain for the first time. The insurance company that we are making a claim with, they're going to argue in this situation that you did not injure your knee in this car accident, because if you did, you would have reported it on day one. So it's really, really important that you get the medical treatment that you need right away, and that you're reporting to whatever doctor you're going to first, whether it's the emergency room, whether it's an urgent care, whether it's a chiropractor, a physical therapist, an orthopedic, wherever you go first, you're reporting all of your injuries from your head down to your toes, and then you continue to do that throughout that case. When you work with Samaroo Law, we'll guide you on how to keep an accident injury journal and how to use that when you go to the doctors for treatment, so you don't forget to report things. And what this is doing, number one, it's making sure that you get the medical treatment that you need to get better, because the doctors are able to diagnose you, to treat you, and so forth. But number two, it's also establishing and preserving a record for me, so that I can go back to that and say, wait a minute, you were injured in the knee in this accident too. You complained of it in the emergency room, and obviously they weren't so concerned because you were also complaining of head injuries, but you did complain of it right away. So it's preserving like that position that I'm going to take later, that this knee injury was caused by the accident.
I think jumping off of that question a little bit, there are definitely times where people suffer an accident, they are injured, but they fail to report certain injuries to a doctor. Maybe they forgot to say something, and then months or years down the road, they end up getting surgery on that same pain point. When it comes around for you to talk about this kind of injury, but it is noted that, oh, a doctor never noted this down in the initial intake or in the initial evaluation, what kind of effect would that have on the case?
It could have the same effect that we just talked about, where the insurance company is arguing that it's not linked to the accident, that these injuries weren't caused by the accident. So what we would do is we kind of scour through the medical records to see how we can link it when you were complaining of this particular symptom. For example, I have a client that a case that I'm working on right now, and my client, he was in a bicycle and he was hit by a car, and he thought that he had shoulder pain all along, and he was complaining of shoulder pain and treating for shoulder pain. And then when he ended up at an orthopedic for a second opinion, he ended up being diagnosed with major neck injuries, and the doctor recommended doing neck surgery because the neck surgery would alleviate some of the shoulder pain, and then after the neck surgery was done, doing shoulder surgery. The insurance company argued that the injuries from the bicycle accident weren't related to the neck, that the neck injuries weren't related to the bike accident.
Mm-hmm.
But what we did is when we went through the medical records, because our client listened to us and he took our advice and he reported everything that was going on all along, we were able to see that he was reporting neck pain from day one, but it was just because the doctor that he was seeing primarily thought it was shoulder injuries, and treating the shoulder didn't mean that he didn't have neck injuries. He was complaining of it from day one.
Yeah. That's very interesting.
Yeah, so he's preserving the record there for us so that we can do what we do and make that position.
Yeah.
Because you're not a doctor. You really don't know, I mean, unless you're a doctor, but for the most part, you're probably not a doctor, so you don't really understand the pathologies and the medical aspect of your injuries. You just know, like, I'm feeling discomfort, I'm feeling pain. Just pay attention to that. You do know your body. That's one thing you know. You know what you're feeling, and you know if it's different, you know if it's painful, and just document that in your journal, report it to the doctors, and that's really the most important and the best thing you can do for your health too.
Amazing. How do I make sure I'm choosing the right attorney?
So when you're choosing an attorney, there's a lot of like good attorneys in Central Florida, but there's a lot of not so good attorneys too. So you're going to want to make sure you find one that matches your needs, whatever your needs are, your communication style, and so forth. And I think the best way to go about that process is by start by asking your friends and family what their experience was with other attorneys. Do they have any recommendations? And if they do, ask them questions. Did the attorney communicate with you? Did you speak to the attorney? If you had questions, did the attorney call you back? That's a big thing that I hear, a big complaint about other attorneys. The attorney never called me back, and that's just not right in this profession as a whole. We have a big responsibility to protect you, and some of that goes with calling you back. Ask those questions, then go look at Google reviews, go look at testimonials, and then talk to the attorney and talk to them about their experience, talk to them about results that they've received in cases that are similar to yours, keeping in mind that one case can never correlate to another because there's so many factors that go into a case, but is it an attorney that gets results? one really, really important thing I think you should ask an attorney is if it came down to it and you had to file a lawsuit in your case, if you wanted to file a lawsuit, if they recommended filing a lawsuit, or it came to that, are they the ones that would file the lawsuit? Because I think insurance companies have profiles on the attorneys, so they know who's willing to, who's able to, and who will file a lawsuit. And the attorneys that are able to, that will file a lawsuit and will file it within their own office, are the attorneys that will get higher settlements, because once you're capable of doing that, they're not going to push you around with lower offers. So I think it's even if your case doesn't necessarily call for actually having to file a lawsuit, is that attorney capable of doing that if push came to shove, and if it was necessary, would they recommend it? That's really, really important to know too, because that could mean a higher settlement value on your case.
Amazing. So going off of the possibility of litigation, talking about how, you got to make sure your attorney would be willing to file a lawsuit. What really encompasses going into litigation? How does it affect certain cases? And I know a very common question a lot of people ask when they go into litigation is, how long is this going to take?
Mm-hmm.
What would you respond to that with?
So I think that one thing that I would start with is that a lot of people get confused about a lawsuit, a claim, and a pre-suit claim, all of that. Because sometimes when they come to me or come to another personal injury attorney and they have a claim, they think it's a lawsuit. But it's not necessarily a lawsuit until you file the lawsuit. And when you file the lawsuit, that's what we call litigation. You're moving this, you're not able to resolve this case for one reason or another. Maybe it's a zero offer, maybe it's a low offer, maybe you guys the attorney and the insurance company are not agreeing as to like what injuries were caused by the accident or how bad the injuries are. Whatever it is, something is not like meshing.
Yeah. So
So the attorney is going to recommend filing a lawsuit, and when you file that lawsuit, that's what litigation is. Everything else, that most of the cases actually settle before that, and we call that pre-suit claims. So everything else is just a claim.
Yeah.
Now, how long does it take? It's lengthier than the pre-suit process, and basically it could take anywhere. It's usually. Now, how long does it take? It's lengthier than the pre-suit process. It could take anywhere from a year plus. And we're dealing with a lot of schedules now, a lot of scheduling issues, coordinating two attorneys' schedules, at least two attorneys. Sometimes there's a multitude of attorneys, but at least two attorneys' schedules, the witness schedules, the mediators' schedules, the court schedules, the getting on the judge's docket for an actual trial. All of that is things that you have to consider. So before that, it was just dealing with, coordinating with an insurance company to resolve a claim. So really it's just two people, speaking and coordinating in that manner. Now it's a lot of other schedules that you're considering.
Gotcha.
I think the next thing to consider after that is, what does litigation really entail? And this is a discussion that I may have with the client when I do recommend filing a lawsuit. Ultimately, I'm never going to make somebody file a lawsuit, but my clients hire me for my analysis, for my opinion, so I can tell them I either recommend it or I don't recommend it and why. And there's a lot of factors that go into that decision too, but I'm going to give you my true and my honest opinion and my recommendation. When you do file the lawsuit, what it starts with us drafting a document called a complaint, and that's where we list out what we think went wrong, who did what, and how it happened, when it happened, where it happened. So we draft the complaint, and then we draft discovery request. That's written discovery request. So that's us asking the defendant, the person that we're suing, that's called the defendant. We're asking them either, can you admit or deny this? Can you admit or deny that the accident happened on this date, for example? And we'll ask them request for admission. We'll ask them something called interrogatories, questions. Can you tell us what happened on this date? And different questions about the accident or whatever we're filing the lawsuit about. And then we'll ask for something called request for production. We're asking them for specific documents. Maybe they have pictures of their car, pictures of our client's car. We'll ask for those sort of things and a lot of other things. So that's our discovery request. Filing a lawsuit entails a lot of different steps. We initiate the lawsuit, we file the lawsuit, we serve these documents on the defendant or the defendants, they respond, They answer our discovery request. Discovery is us seeking information from them, and then they also serve us with discovery request. At some point, we will mediate the case, meaning we go to a mediator to help resolve the case if at all possible. If we're unable to resolve it in mediation, the case proceeds forward. At some point in the whole process, the defense, the attorneys handling the case for the defendant, will send my clients to what's called a compulsory medical exam. That will happen. If we can't solve it during mediation or at some point during the whole process, that's when we actually go to a trial. And it's a jury trial, so a jury is selected and a jury ultimately decides the outcome of the case.
I had a surgery before my car accident and was injured again. How would that affect my case?
So that could be deemed a pre-existing condition, but the beauty of that is in Florida, you can recover for pre-existing conditions if there's an aggravation or exasperation of the case. I think the most important thing to do in a circumstance like that is to be completely honest and forthcoming to your doctors so they can determine how does it differ, what's going on, what changed, and so forth. If you had MRIs in the past, they can do comparison MRIs to that so we can see exactly what's going on and understand that. Sometimes somebody may have a car accident. Hypothetically speaking, let's say you had a car accident 5 years ago, you treat for that accident and you get better. That's another circumstance where we might see something like this. Just report to your doctors that I had this, I treated, I felt better and I was doing well, because it gets documented in the record so the insurance company can't call you a liar. There's a database that the insurance company has of claims where they can see past claims that you've made. So even if you don't tell your attorney, if your attorney doesn't ask, or if you don't tell the doctors, the insurance company can see that sometimes, and it's better that everybody's just prepared that that's a possibility, that they'll see prior treatment, they'll see prior accidents, prior claims, and so forth. And even so, if you end up having to file a lawsuit, then all of that information will be disclosed anyway. So it's just better that you're forthcoming, you're honest with the doctors, and then also it's going to give the doctors the information they need to better treat you and to help you feel better.
Wow, amazing. I did not know that. So I guess moral story is you cannot hide the truth. Does my lawyer have the right to settle my claim without my consent?
Your lawyer does not have the right to settle your claim without your consent. All offers, even if they're ridiculous offers, have to be presented to the client. So a lot of times I may say to my client, this is the offer. I know that you're not going to accept it. I'm in fact recommending that you don't accept it. This is my game plan. So all offers have to be presented to the clients. Sometimes we know what a policy limit is, or we know what we're dealing with, and we'll tell our client, like in the beginning, that this is what we're going after, and if we get it, when we submit our demand, we'll submit our demand in that amount, and if the insurance company comes back and says, okay, we'll accept that, then it's done, and it's not necessarily presented again to our clients. But those offers, if they're lower than what we talked about before, they have to be approved by our clients.
Awesome. I was told that my attorney settled my case, but I still have not received my check. What's the difference between a settlement process and a closing process?
Yeah, so that's just like legal lingo here. The settlement means that we've agreed to settlement terms with an insurance company or whoever we're settling the case with. Sometimes it's an individual or a company, but we've agreed to settlement terms. And then the closing means that the money is being dispersed to our clients. In the closing, that's the point where you'll see your settlement check.
Gotcha.
So,
what is a release?
So a release is a document that a plaintiff or my client may sign if you're injured in a party and you're releasing the at-fault party or at-fault parties of any future claims in exchange for a settlement. You should never, ever sign a release. If you've been involved in some kind of accident or some kind of injury, you should never sign a release without first speaking to an attorney, because sometimes I'll get a call from people or folks saying, I was in an accident and I accepted, I don't know, $100, $300, $1,000, pick a number, and just all relative to whatever your injuries are. Even if it's $5,000, $10,000, if you've got $1 million injury and you're settling a case on your own for $10,000, then we've got a huge problem.
Yeah.
So you should never sign anything like that without speaking to an attorney first and having an attorney review it for you or giving you some guidance, because insurance companies sometimes try to take advantage of people that are unrepresented and they will give you a release. And there's certain insurance companies that do this automatically, but don't sign a release without speaking to an attorney first.
Thank you for that. What is a closing statement and what is the importance of a closing statement?
So a closing statement is a document that's going to show you exactly how your settlement is dispersed and why you're getting a lesser amount than the actual settlement. Out of the settlement, the total settlement, any outstanding medical bills will be negotiated and paid, and then also any costs that the attorney has in the file will come out of that, and then the fees for the attorney fees will come out of that too. The client will get the difference. So it's showing you, for example, in this particular example that I'm looking at, we settled the case for $50,000 and my client got $25,902.24 in her pocket. So it's showing you that all of her doctors had balances, if the balances were negotiated, what was paid out of the settlement, so she can rest assured that she doesn't owe anybody. She doesn't owe the hospital, she doesn't owe the doctors that she treated with, she doesn't even owe her health insurance any money. All of that was addressed. And then it also shows the cost that the attorney had in the file and the fees, so she can see where the money is going. It's basically tracking all of the settlement money, so you can see that all of these people were paid and you don't owe anybody money, or if you do owe somebody money, like who you may owe.
Gotcha, thank you for that. Do I pay taxes on a settlement check once I receive it?
For the most part, personal injury settlements are not taxable. There are certain circumstances when they can be, and that's really when the settlement agreement entails a confidentiality provision or a confidentiality agreement.
Gotcha.
That portion of the settlement is taxable, and that's why personal injury attorneys, or if you have an attorney that's reviewing your release or negotiating the terms of your settlement, which should negotiate a specific amount for the confidentiality portion of your settlement. Now, this is really interesting. The case comes out of a Dennis Rodman case. I think what happened in that case is Dennis Rodman punched or hurt someone from the paparazzi.
Oh, no.
And the gentleman settled the case with him, and he didn't specify what portion was for confidentiality, what portion was for his injuries, and the IRS deemed that most of the settlement or a portion of the settlement was for confidentiality, and that portion became taxable. So that's the case that we use to kind of guide us.
Dennis Rodman setting standards.
Yep.
That's crazy. My child was in the car with me when I was involved in an accident. How do claims work with children?
So the beauty of children in car accidents is that they're really resilient. Their spines are basically like rubber bands. Even if they're injured, for the most part, what I see is that they do really well. They do well. But if your child is injured, what I would do is I would make sure they get evaluated by a doctor or their pediatrician or somebody, just to make sure. Sometimes there's little kids that can't communicate with you, so you just want to make sure. And I'm a mom of 2 kids, so this is, advice coming from a lawyer and also from a mom. Just make sure they're okay, and get them evaluated, and then also pay attention to how they're responding socially, emotionally. Sometimes they have PTSD type symptoms. I've seen kids with night terrors and so forth, and then other kids just do really well. So just pay attention. Your kids are entitled to a claim, but for the most part, and as a mom, knock on wood, you want to just hope that their claim doesn't have too much of a value, because it means that they're not injured. But if they are, pay attention, communicate it with your attorney, and then those claims can be made too. And we make claims for kids all the time.
Awesome. How long do I have to wait to get new insurance after I've been in an accident?
After you've been in an accident, you can get insurance at any different time. You can switch insurance companies, you can change, you can get new insurance. It really doesn't matter when you change. What matters to your claim, to your attorney, is what insurance you had on the day of the accident. So you can change anything after or at any point when you're not happy or you want to change something on the policy. It really doesn't matter when.
My insurance company offered me a very low amount for my property damage claim after my car was totaled. Do I have to accept this offer?
No, you don't have to accept the offer that the insurance company gives you for a total loss claim. Technically, I don't represent my clients for property damage, but I help them with every aspect of it. And in fact, even if they need me to take over, I'll take over communications with the insurance company and so forth. one thing I advise my clients to do is to look for the actual cash value of their vehicle. And I like this website, carguru.com. If you use that website and you plug in the make and the model and the year of your vehicle, then you can find similar vehicles, and you can look for vehicles with the similar mileage and the circumstances are similar to yours, or the qualities are similar to yours. You can look for those, and you're going to want to look within a 50-mile radius of where you live, and then you can get those VIN numbers and ask the insurance company if they can consider those vehicles in their analysis, because that's basically what they're looking for, other cars like yours that are for sale. In fact, the process of determining what a total loss valuation is, it's a lot like real estate, because they're looking for comparable vehicles, and then they adjust those vehicles to become more like yours by either adding money or taking away money for certain things. Another thing you can do to help with the valuation of your vehicle is to look for improvements that you did on the vehicle. So maybe you spent money on brand new tires, maybe you upgraded the radio, whatever it is. Get those receipts together so that you're prepared to give them to the adjuster, so that they know that you had put additional things in it and upgraded this vehicle. It had a higher value than what they are originally thinking.
What is a frivolous lawsuit?
I suppose a frivolous lawsuit would be a lawsuit that has no... A frivolous lawsuit would be a lawsuit that has no standing in court. Maybe it's a person lying about being injured. Maybe it's a person saying that they're injured and they're not. A frivolous lawsuit would be a lawsuit where somebody has no standing in court, where they really don't have the right to bring that claim, and they're making that claim anyway. So it could be somebody saying that somebody did something wrong when that person really didn't do anything wrong. Maybe the person that's making the claim is the one that did something wrong. It could be somebody that's saying they're injured and they're not injured, but there's factors in the claim that are not true, so much so that they actually have no claim. So essentially it's a claim when you really have no claim. At Samaroo Law, we're really blessed with really good, honest clients. Our clients are not making frivolous claims. They were actually injured. They were injured at the hands of somebody else, and they're entitled to whatever recovery it is that we're getting for them. Whether it's a small recovery, maybe their injuries are small, or a multi-million-dollar recovery. Our clients were injured. They deserve every penny that they get. They're not making frivolous claims. They're good, honest people, and I'm really blessed with clients like that. Yeah, the reality of it is, if your case is worth $1 million, then that's what we're going after, right?
Yeah.
So there's no fear in going after the true value of your case. And we have cases like that. We have $1 million settlements, we have multi-million-dollar settlements, and there's no problem there. But the truth is that most of the cases are not those 7-figure settlement cases. So we have all these billboards and all these advertisements talking about that, and even you may even hear me saying things like that, right? Because we're proud of what we've done for certain people, right? But most people won't get that. So when you see that, you become kind of conditioned to believe that every single case is worth $1 million. Nobody would trade their health for that money. If they could go back, every single one of those clients that I gave checks that are in the 7-figure range or big checks, they would rather their health. Because it's really catastrophic. It's really bad. It's surgeries. It's long-lasting, forever-lasting type of injuries and so forth. So at the end of the day, nobody would trade their health for that. So I think a lot of people kind of think they're desensitized to this. So they think I was injured, and the truth of it is, I see injuries on a spectrum. So I see very slight injuries to very bad catastrophic injuries, and all personal injury attorneys or personal injury attorneys probably will agree that we can see things in this spectrum. But no matter what, if somebody takes away your health, if you were healthy before you went into work yesterday and get in an accident, and by the time you get there your health is gone, even if it's on the low end of that spectrum, it's devastating. It's still devastating to that person, because they don't know the catastrophic injury, and it's not for me to say, oh, it could be a lot worse. But at the same time, it's turning their life upside down, because they may not have a car to go to work. They have to go to therapy. It's harassing, it's annoying, they're not feeling well. So to them, it's the worst thing that can happen, and that's fine, because that's how we live our lives, within our own kind of bubbles. But at the same time, I don't have a problem talking to my clients about the evaluation of their claim every step of the way, because things change. We gather new information. If a doctor diagnoses you with something else, that might change the evaluation. What I explain to my clients from day one is when I'm evaluating the claim, I'm looking at 3 factors, and that's evolving sometimes as information becomes available to us. So in the beginning, I might not have information on any of those, right? Who knows what I have information on? But I'm looking at who's at fault and why. Is my client any percent at fault for this accident? Obviously, for example, if they were rear-ended, they didn't cause that accident at all. The person that did the rear ending is most likely 100% at fault, or maybe it's a multi-car rear end, but somebody else is at fault and not them. The next thing I'm looking at is the insurance policies available. A lot of times you can have really bad injuries, and we have to look at what insurance companies are going to pay for these injuries. And if there's no insurance policies available, is there any entity or any person that's able to pay for these injuries? And if the answer is no, then as bad or as slight as your injuries are, there's no insurance or there's no money. So we have to find the money too. So the first thing we said is the liability. The second thing is the insurance policies or the money. And then the third thing is, what are your injuries? And what's the valuation of those injuries in these circumstances? And that's where you may have room to argue and so forth, because we may see it differently. So it's really, really important. And I think one of the hardest things for me to learn as a personal injury attorney, because it's hard, is how do you evaluate these cases? And you just get a feel for it over a sense of time. You draw back on other cases that you've done. You can, even if you have a first impression type of injury, like all of a sudden a couple of years ago I had never had like severed finger cases, and then I think it was like maybe a couple of years ago I had like 2 or 3 severed finger cases in 1 year. And I had to figure out like what's the value of this case. And the way I do it is I start looking up verdicts for jury awards, or
for like loss of limb cases, similar things.
For loss of severed finger cases, or whatever your issue is, a broken tooth, like what's the value of that in litigation, and then going from there, and then also talking to like other colleagues and friends. We always have a group of people that we can talk to, network, and say like, have you ever had a case like this? What do you think? And being able to assess that. But you have to be able to pull all of that information together, and it's somewhat of an art. It's not an exact science.
It seems like it. It seems like you have to put a lot of understanding into the investigative process, and it seems like you have to be really willing to divert from the investigative process you currently have, being able to think outside of the box.
And when you can think outside of the box, you can look for different avenues of liability. You can look for different avenues to argue that your case has more of a value. And I have a lot of interesting cases in mind, but they're current cases, so I don't want to talk about them. But we can use that for another topic. But nothing is black and white. So you want to like, you did ask me like earlier, what am I looking for in an attorney? And the number one thing I value about myself is my creativity. And I think that look for a creative attorney, an attorney that can think outside the box to resolve these problems, to see your injuries, to see your case from a different light, because it's not so black and white. And if you can move and deviate from the normal like process, then we're settling the cases higher. And when we settle it higher, it means that we're giving you more money, we're giving you more peace of mind, more, you can focus on your health, you can focus on your healing, you can focus on being with your family, more fair compensation for what you've been through.
I think it's amazing that, you put a lot of importance on a client having the understanding, rather than everything to them seeming so black and white, making them see how it's more than just that, and how you have to think more than just, it's this way and that way. I think a lot of people, when, they first get into a case, from personal experience, from friends' experience over the years, people telling me like, I thought it was just this. I only thought I had to do this. Having these expectations that are being set and then not being managed properly. People getting an attorney finally and saying like that I haven't gotten a call from them in months. Or they're telling me that they're going to get the most for my claim. I've had people tell me that before. I was promised I'd get the most for my claim, and I'm walking away with $5,000 and $50,000 in medical bills. Like,
I would say if you're promised anything, either like legally or medically, just run away, because there's no guarantees. Like if anybody tells you I've got a magic ball, I can look into the future. I mean, we can make predictions. We can say based on my experience, this is what I expect, but there's no guarantee in any of those realms.
Because you're making predictions based on probability, not hope. And I feel like a lot of people are just hoping that things will work out well, because from that black and white view, maybe there are certain people who still see it from that black and white standpoint.
Yeah.
So they just see it as like, yeah, I think you're worth this much. But at the end of the day, I mean, it has an effect on people. Being promised something, especially at the start of a claim or a case, and being told we're gonna get the most you possibly can for it, and walking away with such a minimal amount.
Yeah. Yeah, no, I mean, just understanding like what we're looking at, how we're looking at it, and what we expect and so forth. That's really important too. So like if you're with another attorney or if you're with us, just ask those questions. It's really important that you understand that. I like that you said that the communication with the clients is important. It's really, really important to me. Communicating with my clients so that they understand what I'm doing, they understand what's expected of them, and everything kind of moves forward more smoothly, and we can resolve the claim more efficiently, more effectively, for a higher value. And it just reminds me, it brings me back to the case that we closed this morning, where my client took my advice and she listened to me and she followed the doctor's instructions where the other folks didn't, and she ended up getting significantly more. And to be honest with you, she did really, really well. It was a really good settlement, and she was really pleased. I was really pleased, and that's the best thing that we can ask for.
Gotcha. Yeah, so I think the most important thing for any potential client to know, regardless of the attorney you choose, is to keep an open heart and an open mind. Listen to the attorney, because they're here for your benefit.
Yeah, 100%. And I like that you also said that communicating with the clients is important, because what came to mind is when you do communicate, and you have that open line of communication, you can come up with creative solutions together. That creativity is not just on the attorney, it's on the clients too. I've had clients tell me things, it just kind of triggered something and reminded me of something. I had clients tell me, for example, if I'm there in college, I suffered tremendously because I couldn't study, I wasn't performing the way I should have been performing in college, or I had to drop out of a class. And when they tell me that, well, then just give me documentation. Show me the grades. Show me the letter that you dropped out, or whatever it is. Show me the doctor's note, or things like that. And we look at all of those things, and we'll submit that with our claim. I don't mind including those things which are somewhat outside of the box. It's not the norm to ask for those types of things. But if my client tells me it's affecting my life in this way, then let's figure out how to prove it. Let's come up with a solution together. How do we show that?